intention to conduct this hearing with the fairness, courtesy, and decorum that is expected of us as representatives. Please help us attain this goal. Madam Secretary, would you please call the roll?
Chairman Lance?
Here.
Vice Chair Dorman?
Here.
Representatives Weber?
Here.
Bratton? Burns?
Here.
Fraker?
Here.
Gosen?
Here.
Hurst?
Here.
Kelly? Lynch?
Here.
Smith? Walker?
We do have a quorum present. We will now go into executive session, and I move do pass on House Bill 285. Is there any discussion?
What's 285?
285 is prevailing wage bill regarding public works projects. Okay. Madam Secretary, would you please call the roll?
Chairman Lance?
Aye.
Vice Chair Dorman?
Aye.
Representative Weber?
No.
Representative Bratton? Burns?
No.
Fraker?
Aye.
Gosen?
Aye.
Hurst?
Aye.
Kelly? Lynch?
Aye.
Smith? Walker?
Aye.
By your vote of 7-2, you have moved do pass House Bill 285. I now move do pass on House Bill 195, also concerning prevailing wages. Madam Secretary, would you please call the roll?
Chairman Lance?
Aye.
Vice Chair Dorman?
Aye.
Representative Weber?
No.
Representatives Bratton? Burns?
No.
Fraker?
Aye.
Gosen?
Aye.
Hurst?
Aye.
Kelly? Lynch?
Aye.
Smith? Walker?
Aye.
By your vote of 7-2, you have moved do pass on House Bill 195. I now move do pass on House Bill 257, which is the School Construction Act, again dealing with prevailing wage. Madam Secretary, would you please call the roll?
Chairman Lance?
Aye.
Vice Chair Dorman?
Aye.
Representative Weber?
No.
Representatives Bratton? Burns?
No.
Fraker?
Aye.
Gosen?
Aye.
Hurst?
Aye.
Kelly? Lynch?
Aye.
Smith? Walker?
Aye.
By your vote of 7-2, you have moved do pass on on House Bill 257. Transportation's next. We'll now open the hearing on House Bill 44. Representative Weber, go ahead when you're ready, sir.
Thank you, Mr. Chairman. I think vision's a very tough question I've asked members of the committee while they've testified now. First off, I'm Representative Weber from Columbia, Missouri, the 46th District. I'd like to thank the chairman for taking the time to have this hearing today. I appreciate it, and thank members of the committee. The subject of House Bill 44 is gender pay equality or the pay gap. About a month ago, a study from the Women's Foundation released in conjunction with the Public Policy Institute at the University of Missouri demonstrated that full-time working women in Missouri make approximately 71% of what full-time working men in the state of Missouri make. This really shouldn't come as any surprise because numerous studies, both here in the state of Missouri and nationally, have documented over time that women consistently make less for performing the same jobs that men do. This disparity has been demonstrated across all levels of education, all levels of income, in all job fields. A previous study also from the American Association of University Women studied men and women a year after college graduation. It compared folks from the same major who were working in the exact same job field 1 year from the date of college graduation. What it found was that women a year after graduation were making 7% less than their male counterparts with the same training in the same job field. It also found that what happened is that gap actually widened over time. So the problem actually grew worse. What this means is that the longer that women work, the more unfairly they're paid. And I think that's a pretty stunning fact, a pretty stunning statistic. The reasons that I care about this issue, I think, are the same reasons that it's important. On its face, it's simply unfair to ask people to do the same work and pay them less money. It's just wrong, and that should be enough by itself, I think, for this committee and this body to try to address the problem. In addition, though, it's a family issue. Women that earn less money, bring home less money to their families. It's a children's issue. It's an issue for our entire economy. So it's an important issue that we address for multiple reasons. What I'm proposing today is House Bill 44. House Bill 44 requires the Department of Labor and Industrial Relations to establish best practice guidelines for dealing with the issue of gender pay and equity here in the state of Missouri. It doesn't establish mandates. It's not additional regulations. It's my attempt at finding a bipartisan solution to this problem. It operates under the assumption that businesses in Missouri don't think to themselves, how can we pay differently based on gender? It operates under the assumption that people want to do the right thing, and that providing tools necessary, we can make a lot of positive change to address this issue. I'll give you two brief examples of tools that the Department of Labor may suggest, although they're clearly empowered by this legislation to suggest whatever they find necessary. Two things that studies have shown have worked in reducing the pay gap. First, having one person in human resources that is designated to examine bonuses that are given within a company based on gender and to ensure that bonuses are given out fairly. If you just say we're going to have a policy of equal pay, that doesn't seem to make a difference. When you specifically assign one person and say, you in human resources, this is your responsibility, that makes an actual difference in making sure that bonuses are awarded fairly within the company. A second issue that has been demonstrated to help in reducing the pay gap is increased transparency in salaries. Here in the United States, we have a sort of cultural norm against discussing how much money we make, and actually reduced transparency leads to a wider pay gap. I'll give you a brief example from actually a friend of mine, somebody that I grew up with in Columbia. After I filed this bill, she came up to me and thanked me for filing the bill, and she told me her story. And I actually wanted her to come testify today, but she didn't feel comfortable doing that, partly because she still works for the current employer. Basically what happened is she works at the University of Missouri. She has got a master's degree. She's been working in her job for about 4 years. She found out that a man who was hired who had less education than her, who had less experience in their job field than her, and started out making more money than she did. And she thought that was unfair. She went to her boss with the documented evidence. She made her case, and her boss said, you know what, I agree, that is unfair, and increased her pay. There's a lot of different things that you can take away from that story. One is that it's difficult to talk about, right? While she's completely right, it had a happy ending, she didn't want to come here and talk about it today because she didn't want to make waves. Second, she showed tremendous courage and being willing to say something. Most people, or certainly a lot of people, wouldn't have had that courage. Third, her boss recognized the problem and agreed that something should be done. But it's also important to note that without the transparency, the University of Missouri published the salaries. Without that transparency, she could have worked for years and never known that she was making less money. If, say that they were given a 2% raise off a different base, that gap would have continued to grow wider. And if she hadn't addressed that issue now, say she worked at the University of Missouri for 18 years like my mother has, and she got a percent-based raise every year. 18 years from now, the gap from what she was making and what her coworker making would be enormous. And if it wasn't for that transparency, that component, this issue wouldn't have been addressed. I think this is a good bipartisan solution. I think this is a real problem here in the state of Missouri, but I think it's a problem that there are clear guidelines on how we can address. And so with that, that's my proposal, House Bill 44. I do have some people lined up to testify, and I'd be happy to take any questions from the committee.
Questions of the representative? Representative Ghostman,
Inquire, please.
go ahead.
Thank you, Representative. I understand the premise of this. I'm just going to more or less talk to you, throw some thoughts out when I think about this. I mean, I've got a wife who makes more money than me and 3 daughters who I look out for, and I would never want this to happen to them. I was working with a constituent on an issue like this a couple of years ago, and we went to some of the largest employers in my district, one being the school district, one being being a large insurance company, and we talked to them, and they put not just my constituent but myself at ease that the pay, in the school district was not based on gender in any way, and this insurance company provided statistics showing their pay based on men and women. And so, I wasn't really able to find a lot of it. I'm not saying it doesn't exist, but with some of the bigger employers, but when I was working with this constituent on it, we started talking about, was the problem maybe more of a job issue? Like this person, I look at some of these counties, and I'm thinking one particular county, I won't name it, but school teachers is a big employer in that county. And union guys, and these particular union guys are doing very dangerous union work. And so that county's there's gonna be a big disparity there. You've got the teachers. I've always said, when I went to work at Anheuser-Busch as a Teamster, and I started out at $24.75 an hour cleaning equipment, and I thought, oh, I wish our school teachers all started out at $24.75 an hour. And so I wonder if there's not more of an issue when you look at county totals of different occupations paying differently. Maybe our school teachers that are often dominated by the women are at a lower pay level than, say, I'm not throwing representative here. There's some jobs, dangerous jobs, or intensely physical jobs that maybe pay a little more that the men tend to gravitate to. That's one thought. And then even the thought, like I have my oldest daughter, her and her son came out with the same degree, and they took different jobs based on what they really wanted out of their life. My daughter, she wanted to be at home. She wanted to be able to start dinner. Matter of fact, she's going to discontinue working here in April and be a stay-at-home mom. Yeah, I'm going to be a grandpa, but it was her choice, and I always wonder if these studies take into account that there are a lot of women that choose maybe to take the job that gives them that flexibility to be home by 4, or just some thoughts. And sure, and I'm sure you thought about that.
I have. I'd say a couple things. First, when you aggregate it out across the entire state, it tends to take into account discrepancies in terms of danger and stuff like that. I would argue that teachers are a low-paying profession in large part because historically it's been a female-dominated field that we've paid less over time. I think there's a lot of different issues that explain that wage disparity, and so I'm not going to say that we can completely solve all of it with House Bill 44, but I think from the issues that you brought up, House Bill 44 would only make improvements. I don't think it wouldn't do anything wrong. The other component is, to me, the fact that it gets worse over time if you move in the same job fields, right? So the examples that you gave of comparing different jobs, when you look at people in the exact same job, the pay gap exists. When you look at over time, the pay gap gets worse. So that would seem to indicate that there is a problem beyond just simply people wanting different things out of life.
Representative Burns.
Thank you, Mr. Chairman. Permission to inquire. I would like to say something too, Mr. Chairman. I know I have a tendency to talk too much. If I get close to time, you just tap that gavel and let me know. I'm not trying to do it on purpose, but sometimes I get a little carried away. I would like to say a couple of things before I inquire. I was on the Board of Education. I think they'll answer Representative's question. You know, when teachers start out, they start out low. There's several reasons for that. When they do that, it's because they are not tenured and it's kind of a trial period for 5 years. But when teachers hit the top of the salary schedule, particularly in areas where we live, that could be $75,000, $80,000 a year, which is probably more than your average union person makes on a 40-hour week. So your bill more or less is talking about same job, should be same pay, correct?
Yes.
Okay, so if I'm a pipe fitter and there's a lady pipe fitter, Senator Walsh was a pipe coverer, dangerous, hard work, paid full journeyman wages. If I'm on that job, she's making the same amount of money as me according to contract. Correct? Or if you're a truck driver and as your bush employee, those things. What you're talking about is disparity where a lady, a woman would be doing the exact same job and being paid less. As you were saying, 71%, gentleman makes 100%.
Correct.
Okay. In the first place, I feel embarrassed and shocked that we should even be having this conversation. That women in this country would make less money than men. And I was just talking to someone on the elevator. You know, I remember when the Korean War was going on. So I'm old, but I remember when that whole thing, women's live become a long way, baby. And I remember thinking at that point, my mother's going to have to take a step backward because my mom used to run our house like a drill instructor. And my wife also did child daycare in our home for 40 years. And when these moms would show up to get their children, good moms, they would be absolutely so stressed, they'd be out of breath, worried about their job, worried about if their child is sick, how do I take this day off and not be penalized? I want to be with my child, but they're forced to work. So I think it's the least we could do in this country, since it's talked about in our Constitution, equal, we are equal. And why women aren't paid the same, I mean, every woman in this room, why they're not paid the same as men is beyond me. And I'm glad my wife's not here because she'd be pointing her finger at me right now, and that's absolutely right. So I appreciate you bringing this bill. And could you tell me how this would be policed? Would a lady have to bring a case, or would it be put in jeopardy of being maybe harassed after it was done and those kind of things?
Right now, so that there's remedies in the law right now for that. What my bill is trying to do is to say that there are problems, maybe not that are intentional, but that are there in society that lead to this pay gap. And if we can empower people with tools to address that, we can take a bite out of that 29%, and we can reduce that 29%. This isn't about additional lawsuits. There's no lawsuits that would result from this bill. That's a separate situation. It's a separate solution. This is about trying to come up with solutions that empower Missourians to address a problem that I think Missourians, if you poll and ask people across the board, they want to address this problem. I don't think the majority of people think that this is right. Giving them tools to solve that, and that's what this is about.
So in your field, being a lawyer, when a lady becomes a lawyer, they're going to make the same amount of money as a male lawyer, generally.
I would have to look at the breakdown of that. I would say that the evidence seems to suggest that across the board they would probably make less.
What would be the reason for that?
Well,
I mean, working at a law firm or working for themselves, they would not be paid, say, so much per hour like the hourly rate of an attorney, simply because they're a woman?
I want to be careful because this study does break them down by occupational fields, and I haven't looked at the occupational field of lawyers, so I don't want to assert that. I will say that the evidence seems to suggest that across the board, women with the same educational levels are compensated less for the same work than men. So the evidence seems to suggest that yes, that female lawyers would make less than male lawyers.
Well, Representative, I appreciate the fact you're bringing this bill. I'm going to support it wholeheartedly. And Mr. Chairman, thank you very much.
Representative Frager.
Inquire, Mr. Chairman.
Go ahead.
Thank you. Gentlemen, I just want to get a clarification. This is kind of a follow-up to Representative Goshen's question, but this report that you've given us, or that's been provided by the Women's Foundation, says medium individual income by gender. It doesn't say by gender and job classification. So can you clarify that this is all the occupations lumped together because it's an average, so.
That one is, there's multiple, there's a plethora of studies on this. Some of them take different approaches. That one is looking at the median. This is the median working, full-time working women make 71 cents for every dollar that the median full-time working man does. There's additional ones that break it down by occupation. And that's the ones that show that the gap expands over time. Like the American Association of University Women would be another one that you could look at.
Okay, so this one for my county, for example, is 70. No, it's 66%. The total of Missouri is 70. But do you know what the average is by job classification by chance?
Off the top of my head, I don't know.
Okay, I'm just curious what that was, because I think that's the one that your bill's really trying to focus on more, right? Because obviously,
Yeah,
like,
I would say that's
because, you know, this includes concrete workers, which are predominantly male, versus house cleaners.
Right, this is, my bill is predominantly focused on people that work in the same even company.
Thank you.
Representative Lynch,
To inquire, please.
go ahead.
Good afternoon, gentlemen.
Definitely.
Just have a couple questions on maybe how this would work if it came to pass. I know that departments kind of have a willingness to create some rules outside the boundaries of promulgation process once in a while, and we have some concerns in our assembly that they do that.
Right.
Would this open the door for the Department of Labor to create a rule mandating gender pay quality standards on public and private employers?
No.
One other question. The bill doesn't require any legislative approval of the gender pay quality guidelines once they're created. Do you see that the legislature will have some part to play in the final process of that?
The way that my bill operates is it directs the Department of Labor to establish those guidelines. No, the legislature does not need to approve those guidelines. I think the legislature would certainly be in favor of any legislation that we passed ourselves that established those guidelines. But my thinking was that we have the Department of Labor, that there are experts over there whose job it is to deal with workforce issues, and so they're in the best position to establish those guidelines. But I would be in favor of us doing it as well.
So it would come back for the legislature for approval of that? The
Correct.
department will take care of it.
Correct.
Thank you, gentlemen.
Representative Dorman,
Thank you, Representative. So I think we've kind of covered the waterfront that don't have it broken down by education level, service level, that sort of thing.
Oh, wait, there's absolutely studies that do.
You don't have it here today, though.
I don't know if the one that I gave you has that. There are certainly multiple ones that do. I've read 2 or 3 different studies even this morning, so I'm not sure which one says what, but yeah, I think it's beyond established as a fact at education level, that discrepancy exists across education levels.
So your testimony would be then that full professors at MU females receive less than males, or?
So I think the committee is caught up in trying to compare.
Well, we're just trying to, I mean, you're giving us this broad, 2 categories.
Right.
Male, female. What else is in that mix? I think that's the point of the questions.
Right, and I think when you tease out everything else, you still find that just that alone is enough across the board. It does not mean that if you take any 2 random people, there's going to be a disparity. What it means is that if you take the sum of everyone, that there is a disparity. So you may be able to take 2 professors at the University of Missouri, and just because there is a disparity or there's not a disparity, it doesn't prove or disprove the larger issue of there being a problem across the state of Missouri.
Well, do you think, I mean, you just take a whole group and start throwing it in one place or the other. I mean, you could obviously overlook some things. I think that's the point of these questions, but we can move on. Other factors that deal into this. I mean, if we're going to bring it up, let's talk about everything that feeds into this problem. I mean, we would agree, I think, that those with higher education levels tend to make more money, correct?
Yes, and
Yeah, in overall.
and the study showed that the pay gap is not as wide. Among people of higher education, there's a wider gap among people of lower education, but that the gap still does persist among people of higher education. The education levels may reduce the size of the gap, but it doesn't eliminate it.
And there may be other factors that do eliminate it. Maybe we're overlooking. I think that's kind of the point of where I'm going.
I don't think that is true. I think
Nowhere in the state of Missouri can the gender gap be eliminated. Is that what you're saying?
No, I'm saying,
Somehow, no way?
no, you said that there are other factors that might eliminate it. I don't think that currently is the case across the board.
Well, then you're saying that it doesn't exist.
No.
There's never a way to overcome, currently, there's no way to overcome the gender pay gap.
No, I'm saying that when you take into account different factors such as education, different factors such as wanting different things out of life, you still find, even accounting for all those things, that there's pay disparity between men and women.
I mean, is that what you'd be looking for with this bill, or whatever it is? It says, why does gender pay inequality happen?
Mhm.
You'd be looking for all the factors that feed into that.
Absolutely.
Because that's what you're looking for.
Correct.
And then how do we achieve the pay equality? So you'd be looking for factors that would be helpful in eliminating that.
Correct.
Okay, good. So my final portion of the questions then. What would this do? I mean, it looks like to me that we're directing the Department of Labor and Industrial Relations to make a study and recommendations. Is that correct?
To actually establish guidelines. So let me,
What would these guidelines do?
right, and so the two examples I gave are suggestions for what those guidelines might look like. The Department of Labor can obviously go further and provide additional guidelines, but those are just two things that have, other states have worked on that have been helpful. I think, like I said, I'm operating under the assumption that Missourians want to get rid of gender pay inequity, that businesses want to reduce the size of that gap, and that by providing them information and tools that they can use to tackle that gap, that 29% will be reduced. I would also say there seems to be some resistance to the idea that this pay gap exists, or if it does exist, why it exists. I disagree with
Is
that.
that a legitimate question? If it exists, then why does it exist?
I agree that's a legitimate question. I would disagree with, I think, maybe some of the questions that have been phrased, but let's say that we do pass House Bill 44, and let's say we do come across these guidelines. We do recommend these guidelines. The only thing that can happen is positive, right? Nothing negative can happen. There's no way that if you're correct, and I'm assuming you're asserting that the other factors explain this, it's not going to cause any problems.
Just asking questions.
Right, you're just asking questions, right? But it's not going to cause any problems. However, if I'm correct in my assertion that the gender pay gap does exist and is a problem, we can see some real positive change. So from that perspective, passing this bill, there's no way that we lose. All that can happen is that we can win.
Let's say we pass the bill and we do what's proposed here, which
Right.
make a study and establish some guidelines, which is a recommendation unless.
If you want to establish additional litigation, we can do that. But I know the committee generally is not a fan of that, so I was trying to find something this committee.
Well, okay, okay. My first question is, who would these guidelines apply to? And if they're guidelines, I mean, we're here to make law, and usually law requires enforcement. So
Is your argument that you would like to build a?
I'm not arguing, I'm asking.
What's your question that you?
This is an inquiry, isn't it?
You think we should have additional regulation? I mean, we could, my thought was that this committee has shown that it doesn't support regulations.
I'm just trying to figure out what you're doing. I mean, if you want to make a study, couldn't the governor do that? Isn't the governor
It's
just
not,
not direct the department to do that?
the studies have been done. This is the Department of Labor actively pushing for best practices.
Best practice guidelines. So who would that, let me slow down.
Right.
Who would that apply to?
It would be available for any business in the state of Missouri to choose to adopt.
And if they choose not to adopt it,
Then the status quo continues.
okay. So there is no enforcement mechanism. It's not a regulation per se.
It's not a regulation per se.
We're directing the department to make a study and give recommendations.
To establish guidelines, yes.
Okay, thank you.
If you don't think it goes far enough, I'm happy to take it further.
I'd like to ask all the witnesses testifying today, or those wishing to go on record for just anyone who wishes to speak on the bill needs to fill out a witness form, please, and leave it on the table. I'd like to now hear from those in support of the bill. Wendy Doyle with the Women's Foundation.
Good afternoon, Mr. Chairman and members of the committee. My name is Wendy Doyle, and I'm the president and CEO of the Women's Foundation. Since 1991, the foundation has been investing in equity and opportunity for women of all ages in Missouri. I am here to testify in support of House Bill 44 because the Women's Foundation wants to help drive economic development and support for Missouri women and their families. Not only do women represent 51% of our state's population, but 65% of Missouri women vote, which is a larger percentage than men and is even higher than the national average for both men and women. At the foundation, research is a large component of our work, and the data and facts, we utilize them to accurately tell the story. In 2014, we conducted a qualitative and quantitative study in partnership with University of Missouri Truman School of Public Policy. Our study focused on the status of women in Missouri. In addition to analysis, we spent a lot of time listening to low-income and mid to upper-income women across the state. And we did focus groups to hear firsthand what the issues are that women are facing. We even focus grouped men, and what we learned is that they have concerns for their wives' ability to generate income to household budgets and for their daughters' need to become economically self-sufficient. To give you a snapshot, our research revealed that positively, Missouri women make up 48% of the paid labor force, slightly higher than the national rate of 47%. Another positive, Missouri women are less likely to be unemployed than are men. All that being said, in Missouri, women who work full-time earn 29% less than men for the same work. Said another way, Missouri women make 71 cents to the dollar that men make. With few exceptions, this income gap persists across racial and ethnic groups, age, educational level, and occupation. As a reference point, the national average is 78 cents to the dollar. Over 2/3 of Missouri's counties, mostly in the northwest and southeast regions of the state, have income ratios below the state average. The widest gap is in Carroll County, where women have incomes that are just 51% of male incomes. You may be asking how the gender pay gap is related to driving economic development. Research has shown that Missouri women who are employed full-time lose a combined total of $8 billion due to this wage gap. This means that if we can work together to close the gap, on average, a working woman in Missouri would have enough money for approximately 73 more weeks of food for her family, which is more than a year's worth, 8 more months of mortgage and utilities payments, nearly 13 more months of rent, or 2,934 additional gallons of gas. There is so much more that we can do to develop best practices to further economic development for Missouri and to improve the lives of women and their families. We believe that House Bill 44 takes the right approach to get to the why there is a gender pay gap, so that together, men and women, we can develop lasting solutions and get the results that we all desire. Economically self-sufficient women will lead Missouri's next chapter of economic growth. And by supporting this bill, you will be investing in a stronger economy for all Missourians. Thank you for the opportunity to testify before you today.
Thank you. Questions for the witness? Representative Gosen?
Tim Barr, please.
Go ahead.
What industries is there, and again, some of the other representatives have asked, like this particular chart is very difficult for me to pull meaningful information from it because it's just standard. It takes nothing else into account. What are the industries where there seems to be more of a problem?
It varies, and it is occupation by occupation. So
but what's one of the worst? I mean, what would be an industry where we would find big disparities among two people come in as a particular job?
It's again, a case-by-case basis, and this is why this research study is important to actually get to the why of this. What we are seeing
Well, like
is,
the representative said, with attorneys, he doesn't perceive, or with higher education, he doesn't perceive the problem. I'm trying to find.
I didn't say that.
No, not as much as some other jobs. I thought you said higher education. I'm just looking for like industries where, where it's a bigger problem.
sure, if,
Like as school teachers, I guess, because everything's pretty standardized with the contracts, or even with a union contract where everything's laid out. I know I made exactly the same as all the ladies that I was hired with. We all had exactly everything the same. Where is this a bigger problem?
as Representative Weber mentioned too, we see most of it in the hourly wage. So the hourly employee, that entry-level position is where we're seeing the biggest disparity. So again, it's a case-by-case of industry, but that entry-level position is where we are seeing the biggest pay gap. And so those would impact the low-income families. Those are
Like mall type jobs?
Retail, for example, is one industry.
That's kind of what I'm looking for.
Yes.
Okay, all right. Thank you.
Thank you very much for your testimony. Are there those here in opposition of the bill?
Mr. Chairman, members of the committee, Ray McCarty, Associated Industries in Missouri, and here a little reluctantly because as I listen to the testimony, I'm not really sure what the bill is really trying to accomplish, and that's why we are in opposition to it. If it's just a study, the department can do that today. They don't need a bill to tell them to do a study, and that's the reason for our concern with the bill. What is it really trying to do? It's setting up guidelines that can be imposed or can be the subject of a lawsuit. That's what concerns us. And if it's just to bring attention to the matter, we've done that by filing the bill, so we wouldn't need to advance it. So certainly bringing light to the issue, no problem. Filing a report, the department can do that without the bill. So we don't know the reason for the bill, and we would urge you not to pass it. Yes, that answered any questions.
Representative Smith.
Inquire.
Go ahead.
Good afternoon.
Good afternoon.
You said something that was interesting to me. I've been here about 5th year, and you said they could do it already, no need to pass the bill. This has happened probably 5 times last week where there was something that a department could or could not do that was, and then maybe that's the part, they can or cannot do it. This says it's going to be done, and it puts firm footing on it. We all know there's an issue. I know you know there's an issue. That's why you said you were kind of reluctant, kind of coming up here. But I think this right here, it can't hurt anything. And if there's nothing wrong, why not, have it put in the statute so it has to happen? What would be the concern from the industry that you represent for it being in law?
Well, with all due respect, the department could do this without the bill today. And if they see the bill's been filed, the representatives brought the bill, there's nothing stopping them from providing a report today that accentuates this.
And they could also not do it.
They could not do it.
And therein lies the
But if the governor were to sign the bill, then that would mean he would favor that. He could very easily pick up the phone, call the Department of Labor, and they could issue the report. So why pass the bill?
Because just say the governor's not for it, or
Then he would
somebody here is not for it, then he wouldn't
sign
believe
the
that there
bill.
should be an equity.
Then he wouldn't sign the bill.
But then hopefully, I don't know, I gotta relate, hopefully there's no opposition to this, because it just kind of makes sense.
Then the governor would just pick up the phone, call the Department of Labor.
Okay, but I think it would be better, if that was the case, we could use that with every bill that you all probably have supported.
Well, unfortunately, the governor doesn't agree with everything we want to do.
Right. So I think this is the best way of going to get it done instead of leaving it up to, maybe somebody will, somebody may not, depending on who's running that department at that time,
Well, Representative, do you think the governor would not agree with this?
I can't speak for him. I'm just representing the wonderful folks of the 85th District. Maybe he's got a representative here or something, but I can't so speak for him. But thank you, sir. Thank you, Mr. Chair.
Thank you very much.
I have a question.
Very quickly, please, Mr. Representative.
So, United Industries, are you aware of any instances where women are paid less than men doing the exact same job? Not talking about education level, entry, whatever it is, same job, they make the same as the male counterparts.
It's Associated Industries in Missouri, okay, just to be clear. And for the exact same job description, males and females, I think under today's law, have to be paid the same. I think otherwise they would have a sex discrimination case. I think the problem comes in when you start talking about equivalent work. And that's where there have been lawsuits at the federal level. I think the Lilly Ledbetter case and some others have tried to draw in equivalent pay where you say, well, the job description is not exactly the same. They pretty much do the same thing. And that is something that still has yet to be settled in the courts. And there are a lot more details that have to be worked out on that before we can support something like that, because you get into really other parts of a person's education and exactly what a job entails. But I think for the exact same job descriptions, a person with exactly the same qualifications is supposed to be paid the same based on their qualifications and not differently based on gender.
I think that's the question, they're supposed to be paid. There was a big case against Anheuser-Busch, one of the executives sued when they sold to InBev that they hadn't been paid as one of their counterparts who was a big-time executive. The point being is, and you say, well, what if the governor wasn't for this, or the governor could pick up the phone? If it's the law, put in the law, and I've seen them in the past few years try to change our Constitution, do a lot of changes in the law for something that seems not quite as important as this. So why not just have a law? And I think that's what Representative Weber's trying to do. It's the law, so you'll do it. If it wasn't a problem, they wouldn't be producing studies and saying women are making less than men, which in my opinion in this country, now maybe in China, that's okay. But here, we're supposed to all be equal. And I'd like to see the first man to stand up and say, no, you're not equal. So, I mean, that's my point, and you don't have to answer that, it's just an opinion.
Well, I guess the question is, if the studies are already out there, what is the purpose of the bill? And that's what concerns us, is what is the real purpose of the bill if the studies are already out there that we're trying to have the Department of Labor do? Then why are we asking the department to do another study if they're already out there? And if they're not, then could the governor just do this anyway?
Well, is this, Representative, is this a study, or is this going to be a law to make sure that we have equal pay in the state?
This actually establishes guidelines, best practice guidelines that businesses can choose to follow.
It's the law.
But it's currently the law. The problem, my assertion is that having simply equal pay mandated by law is not the goal. The goal is to actually achieve equal pay. And so that is one tool that we use to reach that goal. This is additional tools to achieve that goal.
And if these tools are guidelines and it's our concern, then maybe whatever the department comes up with and establishes as guidelines could be involved in a lawsuit. That's our concern. And if it's simply to get the word out on what the problem is and to bring perspective to it, the Department of Labor can do that today without a bill.
I think I'll let the representative explain that. Thank you, Mr. Chairman, for the inquiry.
Okay, Mr. Mike Lewis, AFL-CIO.
Representative Goes, I've got a list, like you said, it truly is everybody from CEOs to secretaries. I've got it right there. Yeah.
Thank you, Mr. Chairman, members of the committee. Mike Lewis, President of Missouri AFL-CIO. Well, it's very true that under collective bargaining agreements, all of them start out, at least on the first page, if not the first paragraph, that there's a non-discrimination clause in that contract that says everyone will be treated equally and fairly. I'm just glad to sit up here and be able to testify in favor of a bill that creates a situation to help everyone achieve some things that are a benefit of working under a collective bargaining agreement between an employer, the union, and the employees. And I'd be happy to answer any questions.
Thank you very much, sir. Are there others in opposition?
Members of the committee, Jay Atkins, General Counsel for the Missouri Chamber of Commerce and Industry. We would echo the concerns that Mr. McCarty articulated when he was up here earlier. We would also ask that if the committee is of a mind to pass this particular legislation, we would ask the committee to consider some sort of prophylactic language that could prevent these, quote, best practices from becoming dictates of the department.
Representative Lynch,
To inquire,
go ahead.
gentlemen, good to see you this afternoon.
Thank you, Representative.
Would it be reasonable to say that there is a regional concern that these guidelines could become mandatory requirements by the department going around the legislative process?
That is our concern, yes. We would like to see any sort of requirements of this nature ought to be vetted through this body.
Thank you, Jim.
Thank you.
Representative Smith,
Briefly inquire.
go ahead.
Thank you. Hey, how you doing?
Very well, Mr. Rivera.
One kind of question, does the organization you represent believe that there's a gender pay equity problem?
I haven't looked at any of this research. I don't know. I just our concern is that what start as best practices and suggested guidelines could very easily become an additional mandate for businesses unless there is some language to specifically prevent that from happening.
And the reason I asked that question is because it came from somewhere, and obviously the bill sponsor was is very passionate about it, because looking at the bill number, it's 44. So out of the thousands of bills that we have now, this is one of the first out the gate. So it's an issue, but I think it's rooted in the issue, the problem that I know for a fact, whether you all want to believe it or not, that there is a gender gap, along with other gaps when it comes to pay, but this time we're talking about pay equity. So that's what I wanted to ask the question. Do you all have a position of, hey, we know it's an issue, or no, we don't know it's an issue, or?
I'm sorry, Representative. No, we do not have a position on that particular issue, and in fact, I'm not here opining on that one way or the other. My concern is that anytime we give a department, an executive agency, the ability to promulgate what could be conceived as rules, that we are putting restrictions in place on businesses without the virtue of having that vetted by this body, and that's what we're opposed to.
Thank you. Thank you, Mr. Chair.
Representative Norman,
To inquire.
go ahead.
Very quickly. Time gets away before we realize it, but I think you kind of hinted at what I'm concerned about. Problem that legislation could solve. We should pass legislation, but yet this way we're kind of doing it, behind our backhandedly saying, well, you make up these guidelines, and would you kind of see that eventually slipping into administrative rules, something to that degree?
That's our concern, yes. I think that recommendations and guidelines, when promulgated by a government agency under the guise of being best practices, I think those things can very quickly become binding in a way that was never intended. And I think that type of rulemaking authority, should it be vested, needs to be vetted by this body and expressly either given or denied. And I just don't see that language in this bill.
Thank you very much.
Thank you, Representative.
Mark. Mr. Atkins, we've heard that we finally got kind of an admission that maybe retailing was an area that this is a concern. I don't see one from Missouri Retailer Association here, but being Chamber of Commerce, you're pretty closely aligned with them. But do you think this bill is specifically targeted at retailing, or at a particular retailer in general, or entry? We talked that it was brought up that it was entry-level positions, which, entry-level can still mean a lot of things. You could have assemblers, you could have stockers, you could have checkers, you could have maintenance people. And obviously, the skill sets to do those different things are different. So do you think this bill is targeted specifically at that industry?
But and as you say that, I can see the Representative Weber shaking his head, and I've read the bill, and it doesn't. I don't know is the answer, and I only know what we've heard in testimony. It does not. I don't know if there is a particular entity or industry that's being targeted here. What I do know is, as I said before, that these types of best practices, should they be adopted and implemented, I suppose, by a government agency without having been fully vetted by this body, then I think we're putting all of our Missouri businesses in a tough spot and putting a burden in place that may or may not need to be there.
And then just a follow-up question, it's also been discussed about this won't be the law, but we already have laws on discrimination, which are very rigid and very easily identifiable. Wouldn't that protect most all of these folks?
I would think so, certainly it would, and incidentally, in the case that the representative mentioned earlier, the Anheuser-Busch case, I do think it's worth noting that Anheuser-Busch actually, at great expense, defended that case and won at trial there. In fact, the jury found that there was no discrimination based in gender or otherwise in that case. I think that's worth noting. So to your point, yes, we have a very robust set of employment discrimination laws that you've heard me testify in other settings, or perhaps could use a little tweaking themselves, but certainly in this case, there is an avenue. If there is some sort of gender-based discrimination, employees certainly have wide latitude to bring suit.
Thank you, Mr. Chairman.
Thank you very much, sir.
Thank you.
Ms. Sarah Rossi.
Good morning, Mr. Chair, members of the committee. My name is Sarah Rossi. I'm the Director of Advocacy and Policy for the ACLU of Missouri. I was going to go into a little bit of history about the ACLU's work on gender pay equality, talk about the Paycheck Fairness Act a little bit, read a quote from an ACLU activist who helped pass the first equal pay law in the 1960s. But I feel like the testimony is getting a little bit bogged down in whether or not these guidelines could be effective and whether or not they could be the subject of a lawsuit. And I think I'll change what I was going to say to speak a little bit about my personal experience with guidelines and policies like this. I used to do a lot of contract work in my previous position when I was in Montana. And a lot of the time when I was asked to do policy work, I was asked to write model policies and guidelines for entities because there was no state law that provided those guidelines. So, for example, I was asked to write a model bullying policy and model bullying procedure for the Office of Public Instruction because Montana, unfortunately, is the last state in the country to not have an anti-bullying law. So there were no guidelines in state law. There was no state law that addressed bullying. So those guidelines that came from the department were simply posted on the website as a tool for schools and other entities to use if they wanted to address bullying but didn't know how. And I think that's what this bill does. So we know that a problem exists. I'm sure a lot of businesses know that the problem exists. And the guidelines will provide that. They will provide guidance for businesses and entities who want to combat gender pay equality but don't know how to do it. It's not a mandate. It's not state law. It's some guidance and some procedure and some policy that people can use if they want to start combating the gender pay gap on their own until better statutes and better laws are actually passed, not just at the federal but at the state level. So I think this is a good first step. I think it's something that people can do by choice. And I think that a lot of good can come of it. And it's not coming, just representatives isn't giving you the guidelines to use. That's what the study is for. That's to figure out what guidelines are necessary and what would be helpful for businesses and other entities in Missouri. I think it's a great bill. I don't think there's any reason to be scared of it, as becoming a mandate or to be scared of lawsuits. I think it's just something that people can use, and I think it's a necessary thing for Missouri right now because there aren't really strong pay inequality laws on the books yet. That's all. I'll sit for questions if you have any. I'm happy to read the quote if you want that I was going to read earlier.
Thank you very much. Appreciate your testimony. Are there others here in opposition? I'm sorry. Not appearing. Mr. Bill Gamble.
Mr. Chairman, members of the committee, I'll be very brief. Bill Gamble, representing the city of Kansas City. And Mayor James, this is the first. I've never testified on behalf of one of Representative Weber's bills before. Certainly, if you have a picture, it'd be great. Mayor James has made it a priority of his administration to establish equal pay and gender equality in his hiring practices and make significant headway, but it's always a challenge to evaluate and make sure that you have fairness and within your system. So it's a top priority of his, and we'd just like to go on record to support the bill. Thank you very much.
Thank you, sir. Representative Gosman.
I don't think I've ever asked you a question when you were representing Representative Weber-Spells. Just a quick question.
Sure.
And that's interesting. So the city, the mayor, the city of Kansas City is kind of taken on a project like this?
Yes, well, I mean, we're a taxpayer. I mean, it's a taxpayer's entity. So yeah, I think it's in the best interest of the city to make sure that you make a practice of reflecting fair hiring practices and fair salary practices.
Have they developed their own model, or is there something? I know, like, when you start a city, there's like a model language for your city statutes and stuff. Is there something like that he's going off of?
You know, I don't know, but I certainly could ask and find out.
Because that's what you're looking at here with this bill, right? To generate something that a city could take on, you know.
They could, it's not limited to that, but it could.
And I just was wondering if there's something.
Sure, I will.
Cities use, because like I say, if you're looking to rewrite all your statute in the city, there's model statute out there, there's websites.
Ordinances, yes.
Yeah, ordinances, I mean, yeah.
Yeah, I know we have a discrimination ordinance on books, and that may include that, but certainly I'll ask the question of our Cecilia Abbott, who is now our acting.
Just curious about what they're using.
City attorney.
Guideline on that.
Sure.
Thank you.
I will do.
Thank you, sir.
Even made me sit down next to Mr. For a second.
Are there others here to testify in support of this bill? Let me see a show of hands, please. Okay. Didn't have Richard Craig yet? Forget you.
Good afternoon, Mr. Chair, honorable members of the committee. For the record, my name is Richard Craighead. I'm here with United Steelworkers District 11 in support of this bill. I've attached to my testimony, there's Institute for Women's Policy Research in Washington, D.C. If anybody wants any more information and facts on this problem. I'm not sure why we're dealing with this in today's time. In organized labor, we don't have those issues. That's one thing you can say about organized labor. If Lane and I are working on the same job, we're going to get the same thing. And I think that's fair, and I think it's just. With that, I'll take any questions if I can answer them.
Thank you, sir. Others testifying in favor?
Honorable Chairman, members of the committee, my name is Bruce W. Holt, I'm a registered lobbyist for the International Union of Painters and Allied Trades. We just want to go on record in full support of this, as we believe equal days work for equal days.
Thank you, sir. Others?
Good afternoon, committee chair. My name is Shirley Breeze. I'm state chair of the Missouri Women's Network. We're very supportive of this bill and have been supportive of pay equity for years and years and years. Many of the things that I wanted to talk about have already been addressed, but I want to point out just a couple of others. When women are not paid equally starting out in their careers, that builds until they retire. They're still not getting what they should be getting, because your retirement obviously is generally based on when you earn. So it really doesn't just establish inequity during your work life. Your whole life is then unequal. And another point I want to make is, someone mentioned Lilly Ledbetter, and those of you who know the case know well about her problems with Goodyear. But it was established that She was doing exactly the same work as the gentleman who was paid a lot more than she was. It was absolutely equal. No difference in education, training, experience, or whatever. So that is one example of not being transparent, which that company wasn't, and her finding out, years and years and years later, till she couldn't really benefit from any increase in salary. Thank you.
Thank you very much. Others to testify? Remind everyone to please complete witness forms at testimony.
Thank you for this opportunity. My name is Jane Krigler, and I'm here from both AAUW and the Missouri Women's Leadership Coalition. The coalition works to get women outside of Kansas City and St. Louis elected to all levels of office. Very appreciative of this effort to look at this. I work in healthcare, even at my age, I still have a job, and best practice guidelines are well accepted. That's what a thoracic surgeon or a person in the emergency room looks to see what the standard is. It doesn't dictate or mandate anything, but it gives you something to work from. I have brought and will leave behind this newest edition of the Simple Truth that AAUW puts out. And they adjust for everything, as the representative said, time off to have babies, to raise a family. And even then, there is a major gap in nearly every line of work. The women face a pay gap. Among the occupations for which the Bureau of Labor Statistics collects data that allow for valid comparison of women's earnings are higher than men's in only a handful. And they do go by industry by industry. They also show in their, and they actually show better for Missouri than the Women's Foundation showed. We're making some progress. In fact, in the last 2 years, we've come up 3 bumps. We've come up 3 percentage points. But they also show that it's going to take another 124 years to, if we go at the rate we're going now, to have women's pay equal to men's. Now that'll be 2139, and I'll be 200 years old then, so I doubt if I'll get around to see that. But there's a lot we can do, and I think this is one step, and because it doesn't mandate anything that shows best practices, it's hard to see what the problem is. But I wanted to also leave, now we were working on the Equal Rights Amendment, and I'd like to leave just this was last year, the brochure or the flyer that we had, because it gives some of the facts for women in Missouri, in addition to what the Women's Foundation has found. Thank you very much. I appreciate the opportunity.
Thank you, ma'am. Are there others here to testify in favor of this bill?
Good afternoon. My name is Ben Burkemper with the Attorney General's Office, and the Attorney General wants to go on record in strong support of this bill.
Thank you very much. Others?
Representative Fraper's gone, and we'll get a picture of you. Autophagian, speak on behalf of Missouri NEA. Our platform speaks to proactive attempts by the legislature to really address concerns about pay inequity. We think this is a very smart approach, putting forth an expectation that the department would do best practice guidelines. Reminds us a lot of times when you all will identify an issue and suggest to school boards that there should be a policy, or maybe that the department would put together a model policy. So it really kind of helps raise the awareness and raise the performance across the state in a way that's more proactive, but without a lot of regulation. We think it's a smart approach. We urge the community to move forward. Be happy to answer any questions.
Thank you very much.
Thank you, Mr. Chairman.
Are there others here in favor of the legislation?
Good afternoon. I'm Nimrod Chapel. It's a pleasure to be here with you. I appreciate you allowing this bill to be heard for a number of reasons and think that I might be in a unique position to speak to it. As a former director for the Department of Labor and Industrial Relations, this type of work is exactly what that department was organized to do. It protects employees and employers without unnecessarily promoting litigation. Now, some would argue that that litigation is necessary to change the business practices. I don't think that it necessarily is. You should allow this legislation to go forward. Now, additionally, I'm also the president of the Jefferson City NAACP. I'm here on behalf of my constituents asking you to please allow some best practices to go forward so that if there are good-meaning people here in the state of Missouri that don't intend to commit the moral sin of discrimination, the state of Missouri can be of service to them. I'll take any questions.
Thank you for your testimony, sir.
Thank you.
Are there others here to testify for the bill?
Good morning. My name is Pam Rich, and I'm speaking today on behalf of Empower Missouri, and I have a statement from Jeanette Mott Oxford. Empower Missouri, formerly Missouri Association for Social Welfare, is dedicated to ensuring social justice for all Missourians. It's founded in 1901, and our strictly nonpartisan organization educates and empowers Missourians on issues including hunger, housing, education, health, and economic opportunity. One of probably our guiding principle is basic fairness in all aspects of life. I will pass out this statement. As said before, presently women in Missouri earn 71 cents of what men earn. We believe discrimination based on gender is still present in our society and it must be remedied. As you know, much financial hardship, both at the time and then later in life, is created by this disparity. And I know I've been in this fight since the 70s and 80s when women are making 59 cents. So one could say, well, we've gone a little ways, but it's been a long, hard pull for 40 years. Thank you.
Thank you very much. Are there others to testify for the bill? Not appearing. Are there those who would like to testify for information purposes? Not appearing. This concludes the hearing on House Bill 44. Representative, thank you very much. We will now open the hearing on House Bill 928. Representative Corlew, go ahead when you're ready.
Thank you, Mr. Chair, members of the committee. My name is Kevin Corlew, representative from District 14 in Kansas City. Today I present to you HB 928, which deals with arbitration agreements between employers and at-will employees. The bill provides that in arbitration agreements between an employer and an at-will employee, the arbitrator must make all initial decisions as to arbitrability, including deciding whether the parties have agreed to arbitrate, whether the arbitration agreement is enforceable, and whether specific claims are arbitrable. The bill establishes certain criteria for when the arbitrator must determine that the arbitration agreement is valid. On motion by a party showing an arbitration agreement between an employer and an at-will employee that does not expressly delegate the issues of arbitrability to a court, then the court must stay any action before the court and order the parties to proceed in arbitration. Arbitration, as you know, is an alternative dispute resolution mechanism. It is meant to be an efficient, timely, and cost-effective for all parties. It is also judicially efficient in that it frees up dockets that otherwise could be filled with more litigation. The U.S. Supreme Court and state courts throughout the nation, including Missouri's, have consistently upheld arbitration agreements as a reasonable and acceptable mechanism for alternative dispute resolution. Courts favor settlements and resolutions reached in ADR or alternative dispute resolution. Despite this stated support for arbitration, it is becoming easier for parties in Missouri who have agreed to arbitration to take the dispute to court, despite having a contract that both parties have agreed to resolve the disputes in arbitration. I will let some of the supporting witnesses today to tell you about how arbitration agreements are used in the employment context and also why this bill is necessary in Missouri. But briefly, the Chapter 435 of the Missouri statute sets forth the Uniform Arbitration Act that spells out the procedures for and the enforcement of arbitration agreements. These provisions state that arbitration agreements are enforceable in Missouri. It is a valid contract that people enter into. A party may challenge the validity or enforceability of an arbitration agreement, and that would not change under this bill. It would just change the form in which to challenge the enforceability or the validity from taking it to the court versus asking the arbitrator to decide those issues. Parties in an arbitration have similar rights as they do in court, such as they have a right to an attorney, they have a right to present evidence, they have a right to cross-examine witnesses, they have a right to subpoena witnesses, and therefore it provides a valid dispute resolution mechanism, and it's before a neutral arbitrator. So it's not meant to favor one side or the other, but these are neutral arbitrators that are certified and well-versed and particularly specialized in certain areas of arbitration. HB 928 just changes just one aspect of the Arbitration Act, and that is it answers the question, who decides arbitrability? That is the initial questions, like whether the arbitration is valid, enforceable, and has it been entered into a correct manner. In 2010, in a case called Rent-A-Center West Incorporated v. Jackson, the U.S. Supreme Court again upheld arbitration agreements in the employment context. The court decided that an arbitrator indeed has the authority to decide challenges to an arbitration agreement, so long as the parties have agreed to it. And this bill before you is intended to set forth the presumption that unless the parties expressly agree that a court should decide arbitrability issues, the arbitrator must decide initial issues such as validity and enforceability. Thus, the bill maintains a balance. It still allows parties to contract and honors those contracts if the parties indeed want the court to decide the arbitrability issues. But unless otherwise stated, under this bill, these issues would be for the arbitrator. That is, the bill would achieve the objective of honoring the parties' contracting objectives. We have a variety of groups, I think, that will testify today in support of it, and I'll let them, I'll be open to any questions that you may have, and then let them also express their support as well. And I will mention that the one group that was unable to be here due to timing constraints, it was Kansas City Power and Light, and they asked me to extend their support as well as those that you'll hear from today. With that, Mr. Chair, I'll be happy to answer any questions for the committee.
Questions of the committee? Representative Walker.
Inquire, Mr. Chairman. Thank you, Representative. I think you probably answered most of the questions that I have, but I just want to maybe go over them again. Is an arbitration enforceable?
Yes, it is. It's a valid contract, and in fact, under the act to which this makes an amendment, these are enforceable. In fact, a party can go to court to confirm the award and get a judgment, actual judgment, which is the same as any other judgment or decree.
Okay, and under your House Bill 928, may a party challenge the validity or enforceability of an arbitration agreement?
Yes, they still may challenge that. What this does is, in other words, I could say that, yes, we've got an arbitration agreement, but it's not enforceable for these reasons, or it's not valid for these reasons. And you can still challenge that. The difference in this bill, though, is that you do that within the context of the arbitration. So you ask the arbitrator to deal with those issues. So, and once again, as provided in the bill, you've expressly agreed that the court should decide those issues.
Okay, a couple more questions. Does a party to an arbitration have the right to be represented by an attorney at the arbitration?
Yes, they do, and this bill would not change that. They could still be represented by an attorney.
Okay, and I think that's good. I think you've got a good bill here, and I support your bill, and thank you for bringing it forward.
Thank you, Representative.
Burns?
Thank you, Mr. Chairman. Permission to inquire?
Yeah. Thank you, Representative, for bringing this. Can I ask you, what is the motivation why you brought this?
Despite the fact that arbitration agreements are upheld throughout the nation, in Missouri, in the employment context, recent decisions have started to cut away about the enforceability of that, allowing issues to go to court that normally would be decided by the arbitrator. What happens is if I'm able to take the arbitration to the court by expressing an enforceable or a validity question or enforceability question, then for all intents and purposes, the case is decided in court. And then what happens is the reasons that I entered into the arbitration agreement in the first place, such as cost effectiveness, timeliness, cost efficiency, those reasons have gone away, and we are involved in costly and prolonged litigation.
Also, years ago, we had the right to strike. Purpose of that was that if something frivolous happened, fine, and it wouldn't necessarily be a wildcat job, which it's a word stoppage, and that kept a lot of things. So you didn't have these frivolous things, well, you have to do this, no, I shouldn't have to do those kind of things. We went to grievance and arbitration. And what happened was that sometimes an employer would push, say, well, we're doing this anyway, just grieve or arbitrate, which caused, which I brought up many times before, the unions to police themselves, because if an employee is guilty, they're not going to go to a $20,000 or $30,000 arbitration case and lose. So we would police ourselves. Does the arbitration you're talking about here work the same way that ours did? There'd be like a pool of 3 arbitrators, and the sides would have to agree, like I picked this one, I picked this one, and the arbitrator would then be picked and both sides could pretty much agree to?
Well, this bill does not specifically address that, but it would not change the way that it's done now, and that is parties select the arbitrator, and sometimes it's specified in the contract, the employment contract, on how that's going to be selected. Like other alternative dispute mechanisms like mediation, where one party, as you mentioned, selects one or more arbitrators that they may want, and the other party selects some that they may want, and then they come to a mutual agreement. And really the whole idea of arbitration agreements is just that. It's to honor an agreement between the two of us. And so this would not change that aspect, that the parties would still mutually agree to who the arbitrator is. And generally those, in fact, most contracts call for arbitrators to be certified under the American Association of Arbitrators, and so they're certified, they're qualified, they're often people that have had litigation experience extensive in that field or previous judges in that field.
A lot of them are, I think, probably by and large attorneys that have that kind of experience. Right. And the thing I was getting at, the reason I asked that is because living through some of these situations when you get hurt on the job, and you go to a clinic, and I mean, my God, some of the doctors you run into say you can go back to work, and you're not ready to go back to work. And that's just what I was concerned about with this arbitration. If it's done through standard procedure, that would be fine. The last question I have is, I know we have several representatives who are in business for themselves. I know a lot of people that are in small businesses. And I think that arbitration can be abused by either side. And if you get, say, a troubled employee that just wants to continually go to arbitration, and it could cost particularly a smaller business, a lot of money, which is not fair either. Are there checks and balances in the system where that doesn't happen? Because again, smaller employer, they're operating on a small margin of profit. And we ran into this in the school district. Custodians and bus drivers and maintenance folks,
were at-will employees, but there was no contract signed. They were merely hired, meaning at will. And we would arbitrate if it got to that point. But if you get a troubled employee, I mean, that could be a real pain in the side for a business, particularly a small business.
Right, Representative, I understand that. This bill does not necessarily direct that particular issue, except from the standpoint of this. Arbitration agreements generally are more cost-effective and efficient. And so, although this doesn't necessarily this in fact does not take away an employee's right to be able to take an issue and challenge it and have a dispute with their employer. But this does provide, though, that it will be done in the most efficient mechanism and cost effective, so that if you know, in cases that you mentioned of continual going to arbitration, you're certainly at least not incurring the costs that you would in court, which would be more.
Okay, thank you very much. Thank you, Mr. Chairman.
Do we have those here to testify in support of this bill?
Thank you, Mr. Chairman, members of the committee. Pleasure to see you again. Jay Atkins, registered lobbyist and general counsel for the Missouri Chamber of Commerce and Industry. We are happy to go on record in support of this bill. We appreciate working with Representative Corlew on this, and are happy to lend it our full support. Arbitration agreements in employment contract are an important tool for Missouri businesses to help lend some predictability and control the costs of their business, be they a large business or a small business. And when they enter into a contract with an at-will employee that contains an arbitration clause, they're relying on that predictability that is built into the contract. The reality is Missouri is an outlier among states and nationally. Most courts in most states look favorably upon alternative dispute resolution as a means of resolving any number of disputes, but chiefly between contracting parties and also in the employment context. So the fact that we're even here today speaks volumes about the state of Missouri's courts. We are one of the very few, if not the only state that has seen this pattern emerge recently of courts refusing to enforce arbitration clauses in contracts. So we'd like to fix that problem. We would like to see a world where the arbitrator gets the first bite at the apple to determine whether or not a contract an arbitration clause is enforceable. I would ask members of the committee to bear in mind, I'm not sure if the representative touched on it or not, but upon the completion of the arbitration process, it's important to note that those final agreements are subject to review by the appellate court should one party or the other choose to seek that review. So we're not foreclosing the opportunity for either the company or the employee to seek further review should the arbitration end adverse to one party, a particular party, but we are asking that the arbitration process that has been contracted for be allowed to go forward first. So I'm happy to answer any questions and happy to go on record supporting this bill.
Thank you, sir. Are there those here in opposition to the bill?
Good afternoon, Mr. Chairman, Committee. My name is Amy Koopman, and I'm here on behalf of Kansas City National Employment Lawyers Association. I'm also a plaintiff side employee attorney in Kansas City with the law firm Boland Wickens. And I appreciate your time this afternoon so that I may go on the record in opposition to the bill. I want to be really clear about what we're talking about. I'm not here to say all arbitrations are bad. I don't think that. But this bill is specifically saying that arbitrations in the employment context, when an employee is having a dispute with their employer, will be given a special footing in the arbitration world according to the terms of the bill. And there are lots of reasons why that shouldn't happen. And so
I appreciate some of the earlier comments about various contexts for having arbitrations, but we got to think about it in terms of who are the parties to the arbitration. When we talk about, well, this is a fair environment where the parties are making decisions together collectively, and it's a cooperative thing that's efficient and it's more time saving, all those things. That's true if you're talking about one business arbitrating with another business, or one CEO arbitrating with another CEO. They're on equal footing. But if you have an individual employee who perhaps has worked somewhere for years, and one day they come to work and they say, you need to sign this. Well, what does it say? Well, sometimes they get a chance to read it, sometimes they don't. But in the end, what they're being asked to do is sign away their right to have their disputes heard in a court of law if later on they do have a problem with the employer. And in order to keep their job, they have to agree with that. Those are not equal bargaining positions, right? And that's why it's unfair in this setting. And unfortunately, this bill focuses on employment context. So I want to make a distinction between arbitration versus forced arbitration, which is exactly what this is. We've got to think about who the arbitrator is, not just who are the parties, but who's the arbitrator. In this setting, you've got someone deciding a dispute who is paid sometimes several $100s an hour, either an individual arbitrator or even maybe a panel of several arbitrators, to decide these disputes. They have a financial incentive to not only go through the arbitration, but also a tendency to side in favor of the party that's giving them repeat business. So think about that again. In the employment setting, who's the party that's typically going to see an arbitrator in the future? Who's going to have another arbitration down the line? It's going to be the company. The employee will probably never arbitrate again. And so there is, both on the front end, if you're saying, let the arbitrator decide whether it's a fair arbitration agreement or not, they obviously have an incentive to say that it is, because if they go forward in the arbitration after that, they're going to earn a very nice pay rate at the end of that day. The other thing is, they've got the issue of repeat business. And I have to tell you that there have been studies done where arbitrators, former retired judges, who have actually honestly said, you have to recognize the tendency that, next week, next month, next year, I may see that corporate representative again, and that does weigh in on our thought process. You can't change that. You can't undo that imbalance of power with this bill. I would also like to talk with you all about some studies that have been undertaken. Specifically, a 2009 study. It was a national study on public attitudes on forced arbitration. This was funded by the Public Welfare Foundation, the Employee Rights Advocacy Institute for Public Policy. This was about 800 people nationwide, so I can't tell you how many were from Missouri specifically or any of your districts, but about 800 folks nationwide, 18 or older, all registered voters. And the outcome of that survey showed that in general, in the electorate, opposition to forced arbitration is strong, it's intense, and it crosses traditional gender and partisan lines. Okay, it's not just Democrats or Republicans, it's a bunch of folks in general, a solid majority, in fact, of Americans, 59%, who were opposed to arbitration in this setting that we're talking about now, where an employee has to arbitrate the workplace dispute in order to keep or get their job. Just a little while ago, we were talking about the equal pay bill, about creating some guidelines that could be established in that area. And it was interesting because our friend from the Chamber of Commerce at that point, when he spoke, was talking about, well, we do have these laws on equal pay in Missouri already. So, whether there's a problem or not, I guess if somebody has that dispute, they can still go to court and resolve that. Under this bill that's in front of you now, if that employer had an arbitration agreement in place, it essentially would do away with that person's right to go and challenge their equal pay disparity. And that affects employees across the board, whether they're hourly folks, whether they're military service members wanting to protect their rights, whether they're a high-paid CEO, okay? None of those people are going to have the same bargaining power if they are forced to endure the arbitration agreements that are being proposed as this bill puts them in front of you today. So therefore, we respectfully oppose the bill. If anyone has any questions, I'd be happy to address those.
Mr. Chairman, in my traditional role, I'd like to ask inquiries. Go ahead. Can you go over the reviewability of arbitration decisions? Do you automatically have a right to take them to the court? Can you put clauses in there that say that this arbitration is final and it reduces your ability to appeal?
Yeah, I think that Representative noted the way that the bill is constructed currently, it is the arbitrator who decides up front if it's going to be valid or not. I guess there is still the wiggle room on the back end that either party, unless they write it into the arbitration agreement, otherwise could appeal it. And frankly, I've actually seen them written so that it goes something like this. We're going to make you arbitrate. We might win, we might lose, we being the company. But if the company loses, we have the right to go to a court and say what happened to the arbitration is not fair. But guess what, employee? You don't have that right.
So it can be written into the arbitration agreement that you can't appeal.
Yeah, and I don't want to speak for you, but I don't think this bill speaks to that. It doesn't require that at this
Right, it
point.
doesn't require that, but I'm saying it can be currently. You can put in the arbitration clause, sort of a final judgment clause that says this decision will be final. And that's currently in the status quo. What this bill does is has the arbitrator decide up front, as the court even say, no, the arbitrator has to decide whether this should go to arbitration. And sort of via that mechanism, you could end up with people not having an ability to get to court. Is that accurate?
Exactly right. Okay,
and what are the consequences of not being able to get to court? What are the differences? What, in terms of procedures, things on the record, why is it important for somebody to be able to get to court, and what is the impact of not being able to get to court?
Well, arbitration is fundamentally a closed process. So you all know that things are not perfect in the workplace. Bad things happen sometimes. And if we essentially rubber stamp the arbitration process that's being proposed here, none of those things are ever going to see the light of day. So if you have, say I'm, giving you kind of worst case scenario, if you've got a chronic sexual abuser in the workplace who's in a position of power, and the company keeps having people in their workforce, abused by this person, go through arbitration, pay him off, it's quiet, no one ever knows. You can keep that person in the workplace for as long as you want to without that kind of public accounting. And
never a record established.
And we think that that's fundamentally unfair.
If the rule of law is misapplied, if I feel it's misapplied by a judge, I can appeal that. If I feel it's misapplied in arbitration, and there's a clause in it that says I can't appeal.
Right.
Do I have an alternative, or do I just have to live with that
That's
application of law?
exactly, and that's why it's fundamentally unfair, because you can have, in an arbitration, you don't have to have rules. I mean, he spoke earlier about, sometimes you say, this is who our panel is going to be. Again, that's being decided on the front end by a company. You don't have, Joe Smith talking to him up front about who should we have arbitrated. 2 years from now, I want to argue that I'm not getting paid enough. But yeah, and the problem is that there's no streamlining for, if you're an arbitrator, do you have to know the law? Do you have to apply the law? You don't.
That's it.
Thank you.
Thank you. Thank you.
Very much. Other questions? Just quick. Representative Burns?
Thank you for being here. Do you make as much as male lawyers in your law firm?
You know what? I wanted to think about that when you asked that question earlier, because I've worked at my law firm for 10 years and I'm not a partner. I'm a counsel.
You better go to arbitration and get that done. Anyway, I appreciate what you're saying, and I think there's always a conflict. I mean, Representative, I think you probably know that as well. You own a business, you're a worker, there's always gonna be some sort of conflict. I mean, we never had negotiation with the school board. It was always meet and confer, teachers and everyone. And for 12 years, it was always the same story. We haven't given us enough money, or I don't have fair working conditions, and all those kind of issues. And that's what I'm assuming you're trying to accomplish. That's what you're saying, basic fairness in the workplace, where people can work and have a good living and not have to worry about these situations. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative Bratton.
Still required. This is a question towards the representative. Now, all right, well, no, I'll just ask afterwards, so thank you.
Other questions? Thank you for your testimony.
Mr. Chair, I think we've got other people that will address many of the issues. If I could address Mr. Weber's question about whether the law provides.
Representative, that's not the quorum.
Okay.
Questions and answers for the bill handler down at the beginning of the hearing.
Okay, thank you.
Those in favor of the legislation?
Good afternoon, Mr. Chairman and members of the committee. My name is Janet Mark. I'm Associate General Counsel at Hallmark Cards, and I'm here in favor of House Bill 928. House Bill 928 is an amendment to the Missouri Arbitration Act, and it provides for fair arbitration agreements for resolving employee disputes and employer disputes, so regardless of who brings the claims. Arbitration agreements are becoming increasingly popular in the United States because it offers very many benefits for both employer and employee. First, it saves taxpayers money and helps an overburdened court system because it is funded primarily by the employer. It's cheaper and faster for the parties. Typically, an arbitration hearing occurs within 6 months or so versus 2 years for a lawsuit. And the discovery process is streamlined. Another benefit, the same remedies available in the court system is available in arbitration. The arbitrator can award whatever penalties, whatever awards he or she wants to and feels is appropriate. Another benefit is the informality of arbitration. A lot of times, a courtroom is very intimidating for both the employee and the employer, and arbitration hearings, for the most part, occur in a conference room. The scheduling of the hearing is based on what the party's availability is and the arbitrator's availability. And the rules of evidence and the rules of procedure are relaxed in arbitration. There is greater predictability in arbitration. Juries have a tendency to act on emotion, whereas an arbitrator is a trained professional specific to the legal issues. In arbitration, a hearing on the merits is more common than in court because parties are less likely to file for or obtain summary judgments. And finally, arbitration provides a confidential forum for the parties to resolve their differences. Recognizing these benefits, the United States Supreme Court has expressly said that arbitration agreements are favored in the law and has issued a series of decisions that affirm arbitration in both the employment and consumer context. Other states and federal courts, including those in Missouri, have followed suit, recognizing the benefits of arbitration and routinely enforce fair arbitration agreements. The situation is starkly different in Missouri, in the Missouri state courts. Over the last 8 or so years, the Missouri state courts have eviscerated long-standing legal principles, including those relating to at-will employment, and have created a moving target of what, if anything, is enforceable under state law. And in doing so, they have acted in an anti-business fashion. It's a who's who of employers in Missouri who have had their employment arbitration agreements struck down or not enforced. And those employers include Anheuser-Busch, Blue Cross Blue Shield of Kansas City, the Kansas City Chiefs, Bristol Manor, McBride and Son Homes, Cintas, and Hallmark. House Bill 928 is an amendment to the Missouri Arbitration Act and does basically two things. First, it takes jurisdiction away from the state courts in deciding those issues of initial arbitrability. Basically, is there a fair contract? So the arbitrator does make that decision. So a forced or coerced agreement to arbitrate is not going to be enforced by an arbitrator. The second thing House Bill 928 does is sets forth factors for the arbitrator to consider when deciding whether an agreement is enforceable under Missouri law. I strongly urge the passage of House Bill 928 to provide for fair arbitration agreements in the employment context, again, for both employers and employees, and to curtail the Missouri State Court's activism and hostility towards arbitration agreements. Thank you.
Thank you. Are there others in opposition of the bill?
Chairman. Good afternoon. My name is Jonathan Burns. I'm a plaintiff's employment lawyer in St. Louis. I'm here on behalf of St. Louis NELA as well as MATA. And I strongly oppose this bill for two very basic reasons. One is the bill, as proposed, throws out decades of basic and the most fundamental contract principles, that two parties have to agree to something before it can be enforced against them. And second, that this bill is something that imposes incredibly unfair, potentially unfair arbitration clauses on employees. And it's important to understand that these types of agreements are not your typical contract that is being negotiated by two parties of equal bargaining power. Representative Burns, you talked about the union context. This is fundamentally different than the union context. Most times, arbitration agreements in the union context are part of an overall collective bargaining agreement that has been where the union is negotiating with the company and has relatively equal bargaining power. In the non-union context, though, where this normally comes up is when an employee or an individual is just starting to work with the company, and the company unilaterally drafts an arbitration clause and gives it to the employee. And it's taking advantage of a Missouri worker in one of their most vulnerable spots. They're being asked basically to agree to a contract or a arbitration clause that the company has drafted, or give up their job and not be able to pay their bills or put money on, put food on the table. And a lot of times these are agreements that are being given to employees who are longtime employees, work for a company for 10, 15 years, and then being asked to agree to this or give up their job. The idea that some of the testimony we've heard here that arbitration is some fair process, quite frankly, is a fantasy. Under this bill, there can be agreements that are fundamentally unfair and essentially deny Missouri workers to any access to justice. Under the statute, if an agreement is deemed valid if it meets certain criteria, but those criteria do not speak to at all whether or not the arbitration clause is fair or reasonable. For example, an arbitration agreement, a company could draft something that says, employee, anytime you want to sue us, you have to go through arbitration. But anytime we want to sue you for anything, we can go to court. It can be one-sided like that under this bill. Under this bill, the Missouri employer can pick the arbitrator. They can say the arbitrator is somebody who we unilaterally select. It could be the CEO's mother. It could be the CEO himself And under this agreement, the arbitrator would have to deem this valid, no matter how the arbitrator is selected. How does that provide an employee an opportunity for justice if they've been wrong? Under this agreement, the employee could be required to pay for the arbitration process. Maybe come forward with $10,000 or pay for the attorney's fees of the employer. Clearly, that type of financial requirement would deny most employees the opportunity to vindicate their rights. But under this bill, that kind of contract would be deemed valid if the company gave that to them in writing at some point. In this day and age, if those types of provisions are in arbitration agreements, you go to court and a judge says that that's unconscionable. I think common sense would dictate that. But the way this bill is drafted, those fundamental rules of fairness have been eliminated. The other big issue I have with this bill is that it throws out the requirement of acceptance. You can impose an arbitration agreement under this bill on an employee, even if the employee hasn't agreed to it or hasn't even seen it. In this bill, if an employee, for example, receives an arbitration agreement and the employee reads it and says, I don't agree to that. And the employee's manager says, well, I'll get back to you on that. And the employee comes into work the next day. Under this bill, under the language of this bill, that arbitration agreement is now enforceable against the employee we opposed against them. Because under this bill, if they've provided the agreement in writing and the employee works yet another day, that's automatically deemed acceptance under this bill, even though the employees expressly said, I don't agree to this. Another common example would be an employer gives the employee a 250-page employee handbook. And buried in the fine print in the middle of that agreement is the arbitration clause. And that diligent employee goes home that night, starts to read through the employee handbook, gets to maybe page 50 before he falls asleep. Comes into work the next day, hasn't even seen the arbitration provision, but continues to work. Under this bill, even though the employee hasn't seen it, hasn't read that agreement, it can now be enforced against them. That just seems fundamentally unfair as drafted, this bill. If you want to pass a bill that's going to regulate arbitration agreements, you need to do so in a way that ensures that there's fundamental fairness in that arbitration agreement and that you have a situation where an employee has actually had a fair opportunity to review it and agree to it before it can be enforced against them. For those reasons, I oppose the bill as drafted. Thank you.
Thank you very much. Are there others here in favor of the bill?
Mr. Chairman, members of the committee, Ray McCarty, President of Associated Industries in Missouri, here in support of the bill. We think it's we support arbitration. That's what this says. I think also to address the questions from earlier, that if the arbitrator has in fact prejudiced the arbitration on behalf of the employer, that cannot currently be appealed under 435, 405. So that is not being changed by the bill. In section 435, 405 also allows appeals if it was corruption, fraud, or if there were undue means. So you have to answer your questions. They can still appeal that to court.
Thank you, sir. Thank you. Others in opposition?
Mr. Chairman, members of the committee, Otto Page on behalf of Missouri NEA. I'll be very brief. The previous witnesses have given testimony which we are substantially in support of. Our concern is with regard to our at-will employee members, which would be support staff, that this might be used in ways that are not fair to their right to justice for discrimination concerns. But actually, I think we concur with pretty much all the testimony that's been heard, because what we heard from the proponents was the support for proper use of arbitration, which we agree with. And so we think there probably is opportunity to draft a bill that would meet all of the concerns that have been addressed for. And we would encourage the committee to seek to do that. We don't believe that this bill, as drafted, addresses all the concerns. We'd be happy to try and answer your questions.
Thank you, sir. Others in favor?
Thank you, Mr. Chairman.
Susan Henderson Moore, lobbyist for J.E. Dunn. We just want to go on record in favor and echo the other proponents.
Thank you very much. Those opposed? Any others in favor?
Hi, Mr. Chairman, members of the committee, Fred Dreiling today representing Burns and McDonald Engineering in Kansas City, and we too would like to go on record in support of the bill.
Thank you, sir. Any others? Are there any here who want to speak for information purposes only? Okay, none appearing. Seeing no further witnesses, that concludes the hearing on House Bill 928. Thank you, Representative Corley.
Thank you, Mr. Chairman.
Thank everyone for coming today. Appreciate you.